Yeah, we'll give it a minute as I'm watching kind of the people logging in. So just out of curiosity, Broncos Super Bowl?
Go Broncos.
Looks pretty good so far.
Yeah, it does. It's pretty scary though, huh?
Who do they have? No, they're at home, right?
Yeah, yeah. Against the Bills.
Oh, Bills, that's right.
Yeah,
Oh, Josh Allen and Cook.
yeah. Who they're just great, right? And we got Bo Nix. He's pretty good, but he's this is his second year, right? So he largely seems to be focused on not screwing up. And then at the last minute when he's really got to get it done, he's come forth for us. So you know,
Yeah, I saw him and Caleb Williams both have seven fourth quarter comeback wins this season.
yeah.
So it's like they wait until the very end to pour it on and do their magic.
Defensive battles is what we engage in, Corey. Defensive battles.
Yeah.
Just like the tax controversy practice.
Oh, that's very true. Very true. All right, we're gonna get going. Again, just appreciate everyone taking time out of a very busy day for a very hot subject as we go forward. My name is Cory Parnell. I'm a principal at BGM. I've been involved in the cannabis space since 2014. And as my partner Jim Marty told me when I first started practicing in the area with him, he said, Cory, this industry is full of hard lefts and hard rights. And I'm like, Jim, I've been around a long time, but definitely this industry, if you're involved in it, it's full of hard lefts and hard rights. Just a
And a
couple.
U-turn or two, I'd say as well.
That is
Maybe
true.
even the wrong way down a one-way street.
Driving against the traffic. Um, but I do want to mention that this is an interactive webinar, so please ask your questions as we go through the webinar. Hopefully, we can get to them. And then also just want to mention that we will be sending out this recording to those people that have registered, and then also we'll be posting on the social media. I'm excited to have this follow-up webinar. I want to take a minute and introduce Nick Richards, who is an experienced tax attorney, and he co-chairs the cannabis law practice at Greenspoon Marder. Um, and, as an attorney, they represent individuals, businesses, but really interesting in regards of Nick. He actually began his career with the IRS and then flipped over to I call it the good guy side or good person side. And he's been practicing for over 20 years and leads the charge um, in the space of the 280E. Um, and then the other individual I want to introduce is my partner, Calvin Shannon. Again, he jumped into the space in 2015 with myself. I've been very active working along with, we have over 600 license holders that we work with throughout the US. So he's been very active, especially on the audit side and business valuation side as well. And again, this the 280E subject always seems like there's sunlight at the end of the tunnel, and then it goes dark, and then it comes back. And um, again, just a very timely um, uh, time to discuss about 280E. What is going on with it right now, and I'm going to just kick it off. I don't, Nick, if you want to kick it off, what's the current status timeline around this federal rescheduling based on President Trump's executive order? What do you see?
Yeah, Corey, thanks for that. And thanks to BGM and everyone who joined us. Corey, we got a lot of smart people on in the participant list. So I would echo your statement that this is interactive and we'd love to hear from you. This has always been a bit of a bit of a group effort, I think, for us tax professionals in the cannabis space. And so that's all. I think that's been rewarding for us as a profession. Um, Timeline. Oh boy, let me get to the right notes here on my little yellow pad. But where are we right now, and how do we get here? I think is the question. So right now, the rescheduling process is stayed. That means it's stopped pending an interlocutory appeal. And it's been at that stage for, I think, about a year now. So let's kind of go back. How did we get here, right? It all started when President Biden made a statutory request to reconsider the schedule of marijuana. That then triggered the Department of Health and Human Services to fulfill their statutory authority and determine the proper schedule of marijuana. In 2023, HHS issued a report to the DEA, a letter to the DEA with a whole bunch of science in it that basically said that marijuana didn't fit the definitional requirements of a Schedule 1 or 2 drug. That report and that determination was binding on the federal government when it was issued. That could be very important when we get to later, just talking about some of the theories that are out there, right? Later in 2024, spring of 2024, the Department of Justice issued the proposed regulatory change. That determination then went from being binding to what's called substantial authority. And that's by law. By law, now that determination is substantial authority. That means it's a big dog in the room and you can't get around it very easily, right? So that all happened. Once that happened, then jurisdiction returned to the DEA. And the DEA then accepted notices and comments, and boy, I can't remember what it was, something like 40,000 comments or 50,000 comments were made, and something like 90% of them were positive. And then the DEA announced that there would be testimony of some of the announcements, and it picked, I think, 25 participants, and lo and behold, something like 20 of them were anti-marijuana groups. They were then sued, and allegations were made that the proceeding and the selection was biased, and the appeals or the administrative court said, yeah, that might be true, but we'll just go ahead and go forward anyway. And then there was discovery. And they found out that not only perhaps were they biased, but they were also colluding with those anti-marijuana companies to help them write good comments so that they would get chosen to testify. And that is where it sits now, and it is up on interlocutory appeal. What happened then last year is we saw President Trump sign an order saying, hey, DOJ, restart the process to move marijuana to Schedule 3. And there was much fanfare around that. There was a press conference. I hope you all watched it. It was quite interesting. And then we heard from the DEA, and they said, yeah, we're doing that. And I think that's where it stands. Behind the scenes, Cory, we're hearing that, the process will move forward quickly, that there is a pathway for the current industry. It could involve a Cole memo or Rohrabacher-Farr amendments or something like that. That's inside information, but we haven't seen any of that yet.
Yeah, interesting. I guess what are we thinking in regards of what rescheduling to Schedule 3 would mean for deductions, credits, tax planning? I mean, is it a slam dunk like?
Cory, I thought you were going to ask what it meant for going to your local farm, a Rite Aid, and what kind of strains they would be carrying. I'll let, but since it's not that question, I'll let Calvin answer it.
Well, with regards to the applicability of 280E, I think the general thought is that I'm going to say that there are probably some clients out there, and I, had this conversation. Oh, President Trump did this rescheduling? And the first answer is no. President Trump didn't do the rescheduling, just as Nick described, he offered a directive to push the rescheduling forward. So now let's say eventually we do get to a rescheduling to three. I think it's generally in industry, it's accepted that 280 will go away. I have, and I think Nick, you may agree, some small concern that would be the case, and I still wouldn't continue to make the argument that 280 is applicable, but that seems outside risk or somewhat remote risk. So the idea is 280 would go away, and license holders that would then be able to take deductions as opposed to currently, right now, they're allowed no deductions. They're only allowed to recover their basis and inventory through the cost of goods sold. So costs are accumulated, inventoriable costs are accumulated inventory asset, um, and then includes cost of goods sold, which is an adjustment to gross receipts to arrive at gross income. And then, like I mentioned, all deductions are disallowed after that. Additionally, all credits and things like that are disallowed. So that's, I guess, not a precise black and white answer. I think the general thought out there is that once it goes to Schedule 3, both medical and recreational license holders will no longer be subject to 280. But I wouldn't say that's an absolute black and white definitive. I don't, Nick, how would you feel about that conversation?
Yeah, Calvin, I think you characterized that right. I That has been the assumption all along. That's really been why the industry wanted to get to Schedule 3, right? Um, and I'll talk a little bit about we're seeing some IRS positions in the current fight to prove that 280 doesn't apply that seem related to the rescheduling movement. And we can talk about that a little bit more. But I think on the positive side of that, so one of the things that we're seeing are these notices that are coming out where taxpayers are filing claims for refund according to the position that 280 doesn't apply and asking for their money back. And the IRS has got a various approach on that. We're going to talk a little bit about that more later. But I think one of the things that they're saying in their notices is encouraging. And so I want to kind of read that right now. It says, why we can't allow your claim. And then it goes on in three sentences. That's all this is the most detailed they've done on this Calvin. Everything else is much less detailed than this. Per Section 280E, cannabis related businesses are only allowed a deduction for direct cost of goods sold with no other operating expenses. I'll stop there. Calvin, we know that's wrong, right? Cannabis businesses are also allowed indirect cost of goods sold if they are incident and necessary for the production of income. So, I want to stop there and just say the IRS has been gutted lately. And we see a number of situations where we are receiving notices from the IRS all across the spectrum in all of our tax cases, whether that's a collection case or an audit where they just don't know what they're doing. And the notices they are issuing are just plain wrong. And we're seeing that quite a bit in the IRS right now. This goes on to say, the law with respect to scheduling or classification of marijuana has not changed. That's right? The law with respect to scheduling or classification of marijuana has not changed. Doesn't mention 280E in that sentence, right? It then goes on to say, unless and until a final federal rule is published, marijuana is a controlled substance and subject to the 280E limitations. That's the encouraging part, right? Unless and until a final rule is published, 280E applies, which assumes that once that final rule is published, 280E won't apply. So that's the encouraging part of what I've heard from the IRS so far, and that's in writing, so that's good. The discouraging part comes a little bit from their arguments that we've seen in ongoing audits and litigation. And that their arguments there tend to focus on the second part of Section 280E. What 280E says is it applies to trafficking in substances, parentheses, within the meaning of Schedule 1 or 2, end parentheses, which is illegal under federal or state law. So far, the IRS position in defense of the position that 280 doesn't no longer applies, which we're going to talk about, is that it's still illegal. And so 280E still applies. That's that second part of that 280E definition. And it'll be really interesting to see if they hold on to that, because as we're going to discuss, if we go to Schedule 3, the current industry is not legal. That doesn't automatically make the current industry a legal Schedule 3 provider. That I think is a substantial risk here. Together, Calvin, Cory, with the chance that this could require regulations, and those regulations may revisit 280E in the context of making it Schedule 3.
Nick, thanks for that. I guess I'm going to go back to two things that you said in there. The first one is, and I made reference to this remote chance that the IRS would still take the position that 280 is applicable even after reschedule, and that's in regards to it still, it's still being illegal in the 280 language. And then I want to go back clear to when you were making reference to language from a notice received by an actual taxpayer in response to their amended return refund claim, taking a position that 280 didn't apply. That the IRS, I believe the language you read was specifically something like until, unless and until
Yep.
the rescheduling happens. So with regards to timing, it would seem like if I was going to strictly interpret that, that would mean if it was sometime during 2026, that rescheduling happened, there's a rule published. That from that date forward, just from a strict reading of that, that's when the IRS thinks 280 goes away. Meaning until then, the first part of 2026 would still be subject to 280 applicable. Would you agree with that interpretation, or potentially that they could take that position?
I think so. There's a body of law about whether tax changes will be retroactive or not. Generally, they're not retroactive unless Congress specifically says they are. And so here, this language, I believe, came out of a notice that came out from the IRS in 2024, that sentence that you quoted, Calvin. And in that notice, the IRS said 280 still applies, and it continues to apply until rescheduling in response to amended returns being filed, right? So, and also in that notice, they said it will not be retroactive. So we'll see. That doesn't mean there isn't a good argument that it is retroactive, and we'll get into that. But so far, this has been the IRS's position.
Yep.
And, I mean, we've had a lot of clients that went back and amended returns, taking a particular position, making all the proper disclosures. But what is and I know we've had clients get notices from the IRS, but that's really the next step then is what if they want to litigate?
Yeah.
And
So
then
Cory,
my other question before we jump onto that is, I haven't heard or seen anything about Truliev's amended returns. So I'm going to go with generic and then come to Trulieve.
yeah. So amended returns, right? So here's what happened. About 2.5 years ago, two things happened about the same time. The case of Canna Provisions got filed in the Southern U.S. District Court for the Southern District of Massachusetts, alleging that the Commerce Clause was not satisfied, and as such, the federal government couldn't regulate marijuana under the Controlled Substances Act. Around the same time, Trulieve announced that it wasn't following Section 280E anymore, and it asked for its money back. That started a process of a lot of companies following Trulieve's lead, because about 2 months later, Trulieve announced that it did get its money back to the tune of about $150 million. A lot of cannabis companies then who filed amended returns got money back. Some got picked up for audit. Trulieve kind of woke up the world. specifically the IRS and Congress, because refunds of that size have to be approved by the Joint Committee. And so that woke up that process, and they were looking for other large cannabis companies that also came before the Joint Committee. And so there were a few early audits that got picked up because of that. We then saw a big gap. About a year went by, and we had 3 audits that we were handling, large public companies. And we didn't see any more audits until about maybe 6 months ago or so. There were about 3 or 4 more that happened. Also, what we're seeing from the IRS is notices, and that was what I just read. Notices disallowing, saying we don't agree with your amended return, we're disallowing or we're rejecting it. And then we're also seeing just the IRS doing nothing. And so what does all that mean, Cory? Like you have to do a real check, right? So if you get a notice, you could just do nothing and say, well, that didn't work. Let's move on. You could appeal it. You could do some other things. I think you want to look real closely at other factors before doing that, and talk to your CPA about risk factors and all of that kind of stuff. But that's what's kind of out there right now. What we're seeing from the IRS is kind of a slow walk, right? They recognize this is in the courts, and they, even though their position is 280 doesn't apply, they are in sort of a let's wait and see mode. And we'll talk about those court cases, Cannabis provisions, and Ultra Health next. But I'll stop there.
Yeah, that kind of leads me to how the IRS enforcement of 280 has been evolving with the new tax.
Cory, I don't hear you too well.
Okay, how about now? Any better?
Yeah, better.
A little better, yeah.
You look better too.
All right. Well, I like all my clients say, you can send a bill, but doesn't mean it's getting paid. Yeah, my question that I had was how IRS enforcement of 280E is evolving through new tax court cases activity that we're seeing go on right now.
Yeah. Yeah, so let's talk about those 2 cases, Cannabis provisions and Ultra Health, right? So like I said, it kind of really hit the press when Trulieve announced that it got a $150 million refund. It really kind of started about 2 or 3 years before that, when Supreme Court Justice Thomas made a statement that a case called Gonzalez v. Raich may no longer be good law. That kind of started a process of challenging that case. Gonzalez v. Raich says that the federal government can continue to regulating intrastate cannabis activity under the Controlled Substances Act and the Interstate Commerce Clause. So you can regulate a wholly single state activity under the Interstate Commerce Clause that gives the federal government the authority to regulate commerce that crosses state borders. So there was the fight that, hey, look, our commerce doesn't cross state borders, and the conditions that were in Gonzalez v. Raich back in 2005 when you held this was okay are no longer true. What's no longer true now is that the federal government has taken a hands-off approach to enforcing the Controlled Substances Act against the industry. If you remember, in 2005, they were locking people up. Now, things like Rohrabacher-Farr amendments, the Cole memos, the authorization of Washington, D.C.'s program, all of those indicate the federal government's hands-off approach. And if the federal government no longer has an interstate purpose, they can no longer regulate an intrastate activity. That's the essential fight that's in Cannabis provisions. And the good thing about that is that the district court said, look, that's a Gonzalez v. Raich, that's a Supreme Court case. We can't overrule them. You're going to have to go talk to them. So we're going to have to dismiss your case. But they also said the argument was, quote, persuasive. Persuasive is a very powerful word in taking a tax position, because you have to be reasonable to take a tax position. And persuasive, certainly, while probably not a specific legal term, sounds better than reasonable. It sounds like that's more certain than reasonable. So that was a real nice kind of moment for the position that 280E doesn't apply. Moving forward then, Um, Also, what happened around the same time is that HHS report came out. And then about 6 months later, the DOJ report, uh, and um, and then the Ultra Health case was filed. There's been this question always along this argument about whether it only applies to medical companies or it also applies to adult use companies. And that's specifically because that evidence that I mentioned, Rohrabacher Farr, Cole Memo, Washington, D.C., those are all medical programs, right? And so that's medical evidence. And what the First Circuit said when the case went from district court, where the district court said it was persuasive, up to the First Circuit is, hey, look, your evidence is medical, but you guys are adult use. What are you talking about? Uh, and then, right about the time that President Trump announced that it wasn't going to, in fact, at the time that President Trump announced that it wasn't, that it was going to move marijuana to Schedule 3, we got the Supreme Court's denial of cert on the Cannabis provisions case. Um, so that was that. That was so it was convenient at the time, but now they've denied cert on it. So now that argument, unless you are and I do see some good folks from Washington, D.C., unless you are a medical only provider, that Commerce Clause argument is no longer viable. What is still viable is the within the meaning argument. And it's important to understand that there's a couple different pieces out there about this within the meaning argument. And many taxpayers, if you were a client of mine, you took both positions. The within the meaning argument is unaffected by the denial of cert in Cannabis provisions, and it is at issue in the Ultra Health case. Uh, Also at issue in the Ultra Health case is the Commerce Clause argument for a medical provider. So what Cannabis provisions and the Supreme Court took away is gone, but what was remaining after that is in the Ultra Health case. That case was submitted, fully agreed as to the facts, and now it's just a legal question for the tax court. It's important to understand that there's sort of three different things going on here. Before the HHS announcement, which would mean that you'd have to prove that the HHS determination would apply to previous tax years. Let's call that retroactive. I don't think that's exactly the right word, but it's a good word to use. So in Ultra Health, they're going to have to prove that retroactively the rescheduling would, or the determination that marijuana doesn't fit the definition of a Schedule 1 or 2 drug also applies in earlier years. That's at issue in that case. The later years is not at issue in that case. So that case should not affect years after the HHS announcement. And then the third period is, well, what if we get rescheduled? What does that look like? And interestingly, the government's response in Ultra Health is due by Friday of this week. And we hope to see some analysis on the merits here and the government's position on what they've been saying so long. It's still illegal. Let's see your argument behind that. But we'll see. They could just take a position that it's not retroactive and kind of stop there. Cory, let me say one more thing. This is all very interesting, and then I know Calvin's got about 13 things to say here. But it was really interesting the way it all went down last year, right? We were all waiting for the Supreme Court to grant cert in canon provisions, and they met on Friday. I think it was the 12th of December. The Supreme Court was meeting on whether to grant cert on canon provisions, and that was the same day that Trump announced that it was going to move marijuana to Schedule 3. I don't, trying to look behind the robes here is probably a fool's errand, but it was interesting because if he does move it to Schedule 3, is canon provisions moot? And it was that the reason why the court didn't grant cert. The timing is quite interesting there. I've had a number of CPAs bring that up with me as well. And now here we are. And so I'll stop there.
And this is again before we move on to any discussion about what the removal of 280 could mean. I still want to stay back and keep the conversation before rescheduling. And specifically, and Nick, you made reference to Some of your clients who have taken aggressive positions with amended returns and or originally filed returns, and we have as well. And these clients have gotten notices back. So, in light of the Canada Provisions case and the pending Ultra Health case, is there anything for a license holder to consider when they continue to file amended returns to the extent that they may be doing that? B, proceed with filing originally filed returns taking such a position, or lastly, respond to IRS notices. What should they consider from what's come out of these court cases, or hopefully will come out of the Ultra Health case in the near term, when proceeding either down one of those three roads?
Let's do that last one first. If they consider fighting this, they have to be ready for expansion, right? You get a notice for 2022, and you appeal that notice, and now the IRS is looking at 21, 23, 24, maybe not 21 because the statute's expired, but it could expand, and audits generally do expand 2-3 years. It could also expand to other companies within the enterprise. And ultimately what that means, because the IRS right now, this is in the courts, and so they have no ability to say yes right now. Really, what this is about right now is let's wait and get there. And so that reality of that is you could end up being in an expanded situation along with having to just wait and the IRS just being a firm no. What's left over, though? What's left over? It's not that the amended returns are now wrong. We don't know that yet because the Ultra Health case involves the 2018 year. And if they win, then 280E doesn't apply beginning in 2018. So now those amended returns are good. So that's still out there. It's still good. And that is the within the meaning argument, right? That marijuana is not within the meaning of Schedule 1 or 2. That's what 280E requires. And the federal government has said, and that is substantial authority, that marijuana doesn't fit the definition of 1 or 2. The IRS doesn't seem to be attacking that part. They seem to want to avoid, what we would say is, well, there you go. That's good. So, and Calvin, it's important to understand that that's a much better argument after they said it. So in years following 2023, you don't have to prove that it would apply to earlier years, right? So that's why that's a different analysis. And, Calvin, I tell clients that it's more risky to file an amended return for sure. You should expect the IRS to audit you. That's what they're trying to do. But moving forward is definitely less risky, and I think the position is a lot stronger. What is the IRS saying? In these audits, they're very quiet. They don't want to talk about it. They basically what they say is, well, Nick, it's still illegal. And if I go into the definition of 280E, they say, well, our counsel is telling us that 280E still applies. And that's all they'll say. And that's why we're quite interested in the Ultra Health brief that's going to get filed this week if they say more.
So, say a couple different things with regards to potentially appealing a rejection notice. Probably the advice is to consider risk heavily with your tax advisors, both attorney and tax CPA. Understand what the risk of appealing may be and what the benefits of appealing may be, and make an informed decision based on your specific circumstances. And
I think that's right, Calvin. And I always say this too. The IRS is full of personalities. We don't know what personality we're going to get, right? There's some people out there that take their job extremely seriously and think the industry is criminal and want to charge down every road to try to prove that. And there's some people that just want to do their job and want to go home at the end of the day and just take the project that's giving them and do the bare minimum. We don't know what you're going to get when you get to the IRS.
And then I suppose the same cautions would apply to taking a position and filing an amended return that you haven't already done yet. Just consider the risk, and then maybe as of late, or at least it's been my experience, that the IRS is rejecting more of those out front than they were amended returns that were done let's say, a couple years ago.
Yeah, I think that's right. I think 24, we didn't see many get rejected. And then last year we started to see the IRS able to reject more of them. Calvin, there's another way to go too, which is protective claim, where you file a protective claim for a refund, which satisfies the statute, 3-year statute to file an amended return, but it just sort of sits there and the IRS doesn't really look at it. You just get a letter every year that says, "Hey, we have this. What do you want us to do with it?" That would be a way to.
I guess the last comment is not to, filing originally filed returns taking this position may present some less risks or some different risks. It's still important to be aware of exactly what you're doing and get good advice. And in my opinion, probably a legal, even in that situation, getting a legal opinion from a reasonable basis, legal opinion from a qualified law firm to even go down that road. Or that's still what I'm advising people anyhow.
And I think that's pretty uniform across the CPA profession as well.
Yeah, I actually was presented one with a new prospective client that they created in ChatGPT AI position to be attached. It's like, yeah, no, that really doesn't work for us. You know, again, you want adequate coverage within the filing of the return, but when it gets kicked back, you want to make sure the legal mind that put that together in the possession can articulate and argue it, right?
Cory, was there any hallucination in that ChatGPT report?
There definitely could have been. Nick, can you touch on, you mentioned that there's another brief coming up this week, or maybe I think I heard tomorrow.
Yeah, it's due by the 16th. And in the tax court, a lot of times the tax court's kind of a friendly venue to try issues. There's no jury. And in Ultra Health, what they did is they submitted it fully factually agreed. So they agreed on all the facts. And then that's called Rule 122, if you must know. And then the plaintiffs, the cannabis companies, the petitioners in that case, filed their brief arguing that 280 didn't apply, and it's a good brief. It sets it forth very well. And then there were a number of seriatim briefs that got filed. We filed one seriatim brief. A seriatim brief is like a friend of the court brief. It's where oftentimes law firms or interest groups that aren't part of the litigation but have a stake will file their own briefs. And now the government's brief is due this week. It was due about 30 days ago, but they got an extension, and now it's due by the 16th. Like I said, they could just take the position that it's not retroactive, or they could argue the merits and as to whether the within the meaning argument has any bearing. It's a tough argument for them because statutory interpretation comes into play here. And around the same time that the district court issued its opinion and said that the argument was persuasive in the Commerce Clause argument, a case called Chevron got overturned by the Supreme Court. Chevron is a case that says that the court should defer to agency interpretations. So now that's gone. And so the IRS's interpretation of 280E no longer has the weight that it used to. So now the court has to actually look to the statute itself and interpret the language. And the language, again, trafficking in a substance, parentheses, within the meaning of Schedule 1 or 2, end parentheses, which is illegal. So the IRS is pointing to that which is illegal so far informally and saying it's still illegal, so 280E still applies. Statutory interpretation would suggest otherwise, right? That comment, which is illegal, modifies the prior comments, and it isn't an or, right? It isn't Schedule 1, Schedule 2, or illegal. It should be interpreted as an and, Schedule 1, Schedule 2, and illegal. So we'll see if we get into all that. The petitioner's brief did get into that, and so hopefully the IRS will respond to that.
So it could be a lot of good stuff coming from this IRS response that would be telling in a lot of ways, how they feel about these arguments and what their potential and what their response is going to be. And I emphasize could because maybe not. Maybe they'll just skim over it and I guess save it for the court, huh?
Yeah, yeah, we'll see. We'll see.
Yeah, one thing that you make me think of though, Nick, and I can't believe I think we first started uh, filing returns under 481 little C.
Yeah,
Um,
471C. Yeah.
yeah, I'm sorry, 471C. I think it's been about 7 years already. Um, have you seen much activity in that lane? And again, we've taken that position with a lot of our clients and feel very comfortable with that.
Yeah. No. The only audits that I've seen that are 471C audits didn't start out that way. They were, in the COVID era, we saw a few audits. The IRS targeted the cannabis industry, right? And they got everybody's number, and they built a bunch of files. And those files then are sitting there. And when revenue agents need to do something, they give them a file and they audit that company, right? And so COVID happened. The IRS didn't have much to do because that the process stopped, and they picked a bunch of the small companies that were caught up in those targeted audits, but hadn't yet been audited. They were like the low hanging, or the high hanging. Let's not worry about these folks. They audited all the big guys. They learned that 280E, the big guys couldn't even pay it. So what is this worth? And then they didn't have anything to do, so they grabbed a bunch of little guys. Those little guys, a bunch of them were 471C. And what we saw of those, that first kind of wave of audits then in the 471C world was a number of no changes. We actually got 3 no changes in audits that we handled. Those no changes appeared to be where we had a good partner like you guys that was handling the books and records, and the books and records were really tight. And when we had that situation, the IRS said, "Yeah, we don't want to talk," and they just issue a no change. Doesn't mean that they're saying we're right, but it means that they're saying that they're not going to take any position. They're not going to take action against us. We also had some cases where they didn't issue no changes. Those cases were where taxpayers did it themselves, didn't have a good CPA firm, or they handled the audit themselves and we jumped in last minute, some of that kind of stuff. So the records were a lot more messy in those cases. And in those cases, the IRS took the position that 471C didn't work, and we ended up settling those cases anyway on other ways. I know a number of other tax professionals like me have had that same experience. Uh, Cory, we haven't seen a 471C audit for years since that. There are a couple that we've gotten in this last wave that were tax opinion, no 280E clients as well. So we've got that now. So it's interesting. And we'll see kind of where all that goes. But yeah, I think, Cory, it's interesting, right? When 471C came out, all the real big guys were like, oh no, stay away from that. But then when the tax opinions started coming out that 280 doesn't apply, all the big guys are like, oh, we like that. So I don't know which one's more risky, to tell you the truth. I think that there is good reason to use both if you can. And in the 471Cs that we've taken, we try to take a reasonable approach, and I think that's really important. And I think that that idea that you can just do everything with 471C is problematic. I think a proper 471C accounting method gets you about halfway there. And there's still some costs that are subject to 280E in that analysis. And then that takes us to the other thing that we don't know if it still survives or not, but the 280E capital asset method, right, where a lot of companies are taking those costs that don't go into cost of goods sold under 471C and capitalizing them and carrying them forward. And Cory, I'll say that last part, that capital asset method, that's been around for a long time,
Yeah,
a long
forever.
time. And it sort of got started as just a, God, what do we do with these 280E things? Let's let's just capitalize them for now and start carrying them forward. Maybe something will happen. Just capitalizing them doesn't, there's no tax effect to that. And then when 471C came along, we took a look at that again and we said, well, hold on, this is interesting because, you know, what 280E says is it applies to trafficking in substances within the mean. It's got to incurred during the taxable year, paid and incurred during the taxable year. Well, once you capitalize and carry a cost forward, it's no longer paid or incurred during the taxable year. It was paid and incurred last year. So now if you have an accounting method, and 471A doesn't get you there, but 471C might. Now, if you have a more flexible accounting method, can you start to work those costs back into cost of goods sold? And that's the classic 471C method that I think most of the industry is probably using. And that Calvin, Cory, we kind of developed that method, right? And I think we did a very early webinar on 471C, probably in 2018. And I think once again, yeah, I'm leading the charge.
You know, with regards to 471C, since that has come up, there's a couple areas that I wanted to go into just briefly. And you had kind of mentioned this, Nick, about taking the aggressive position that 280 doesn't apply. The idea of, to the extent that you were previously doing 471C or weren't yet, and you're eligible. I always have to emphasize that because there's a number of ways that taxpayers could potentially not be eligible to account for inventory using 471C. But assuming you're eligible, and let's say you were using 471C before, which granted has some downside because the whole concept is these costs are first inventoriable, so you have some timing deferral. So some of the costs that you're saying are not subject to 280 or not deductions are hung up in inventory. So it would be possibly advantageous to say, oh, well, we're taking a position that 280 doesn't apply. We're abandoning 471C, possibly doing an accounting method change. I'm going to speak a little bit more about that in a second. And accelerating when we would get these deductions. I guess my general thought is I would have some reservation about that. For one thing, this 280 position is based on a reasonable basis opinion, which means definitely less than 50% likelihood of succeeding. And we talked about the CANA provisions issue as well, and what that could mean for that position. But then even let's say rescheduling happens. All right, so it's definitely rescheduled happens, and we have some good evidence that the IRS is not going to push 280 on industry anymore. But they are still saying that before rescheduling, 280 was applicable. I guess, and this isn't a problem that we've had to solve yet or think about much, but you know, I've started leaning into it, and the idea that you know previously you're using 471C to account for inventory, capitalizing a lot of these costs to inventoriable costs and inventory, and increasing your cost of goods sold, decreasing the amount of 280 that you have. And a lot of that, as Nick very well described, is based on underlying books and records, and I would argue possibly some consistency with it with regards to how you account for these costs. So I guess I would just offer some caution that all of a sudden 280 is gone, saying, oh, well, we are going to change now how we account for inventory and stop capitalizing these costs so we get more of an immediate deduction. Because it would seem that would open the door for the IRS to make an argument to say, yeah, okay, you're not subject to 280 going forward, but a lot of the costs that you were previously capitalizing as inventoriable and including in cost of goods sold in previous years are now up to argument. We're going to argue that those were not cost of goods sold. And I guess that, like I said, this is just preliminarily something that I've started thinking about and exploring it as we anticipate what 280 going away might mean.
I think, Calvin, that you know, don't first off, don't just run off and do it. like talk to Calvin and me if I'm your lawyer, and let's take a hard look at what moving into Schedule 3 looks like. There is a within method change, right, for a 471c taxpayer. So I'm not saying you can't do it, but take a hard look. Also, that if you've been capitalizing and carrying forward that 280E capital asset, you've declared a useful life on that capital asset. If you change that useful life, that requires a change of accounting method request. That's not an automatic change and I believe would require IRS approval. So I think that sticking with the useful life that you have declared on that asset, even if you take the position that 280 doesn't apply, is probably a good idea. Although I'll say, Calvin, we just saw they just extended the 100% deduction for depreciation of capital assets, right? So it's attractive. But yeah, be careful.
I think that's just the biggest word here is consult your advisors, understand your risk with regards to all these, and make informed decisions.
Yeah. And that was the advice on if you're already 471C and you want to utilize the no 280E position, right? Just keep doing what you're doing, but those costs that you were capitalizing, not that you capitalized before, but those same costs in the current year, now you can deduct those costs. But you don't start deducting those past costs, you stick the course with those costs.
Yep.
Yeah, that you just again, this is ever changing landscape. I always call it the shifting of the desert sand. One day it's great and you're moving along, and then all of a sudden you just see a big windstorm, sandstorm coming up behind you. One thing I do want to touch on, only because we've seen some other clients go ahead and move forward with doing an ESOP, even with the possibility of rescheduling. Any thoughts on that? And again, I know we have several clients that have done or are doing that currently, moving to an ESOP.
Yeah.
Yeah, I've seen that a bit too.
Oh, you go ahead, Nick.
No, go ahead, Calvin. I just was saying, yeah, I've seen that too.
My comments with regards to ESOPs, for one thing, it is a fantastic 280 mitigation tool. There's no doubt about it. It doesn't matter what the IRS says your income is. If the tax rate is zero, which the ESOP trust, the tax rate is zero, then it's a definite tax saver. But I guess I would just caution, with or without the 280 advantages, that there are other considerations that a business owner would need to think about before doing an ESOP. But the first and most important one is, do you want to sell your company? Because that's effectively what you're doing. Is it a fit for you? And sometimes it may be a fantastic fit, and it could have a whole bunch of advantage, including employee morale and good marketing. But again, just something to consider, all the advantages and disadvantages, and work it, talk it through with your advisors to make sure that it is a good fit for you.
Yeah, I think that's right, Calvin. And we haven't seen a case yet involving 280E and an ESOP. I just point that out. But I think my interpretation is the same as yours, Calvin. But it's interesting when the law considers the law in context of a marijuana litigant, and things tend to go sideways, right? They tend to bend the law when it involves a marijuana litigant, unfortunately. So I don't know. I think that what you said is right. If it's right for you, let's put 280 aside. If it's right for you for all these other reasons, great. And hopefully it also does away with 280.
We do have a question. I'm going to read it. I have some protective claims denied by the IRS. They're using the same language as what you mentioned in the exam notice, that 280 still applies. Further, they cannot hold a protective claim based on potential litigation. Any advice?
That's just wrong. We actually have one of those too, and we appealed it. It a protective claim by its very nature is because of pending litigation or something like that. That is the purpose of a protective claim. A protective claim is a procedure that basically says, hey, something's going on that could change the law in the future. And if it does change in the future, it could affect me for this tax return. And so for that reason, I am filing this return as a protective claim in case the law changes. That's the very purpose of a protective claim. I think that is another example of the IRS losing all of their skilled workers and having a bunch of brand new people there that just don't know what they're doing.
Well, I guess
Yeah.
my one comment to that is there are some technical things that you have to do, not a lot of things, but there's some things you have to do to make sure that this is a protective claim, and the IRS couldn't take the position that this wasn't a protective claim, but that actually filed an amended return for refund. Um,
There's generally two ways to do it, right? You either file an actual tax return and amended tax return, and you write in red ink on the top, protective claim for a refund, or you provide a letter that sets forth enough of the information that would have been on the protective claim, the refund claim, to satisfy the requirements. I think that the comment was they probably filed a return and wrote the red on the top, and that should work.
Yeah. Yeah. Well, we're at the top of the hour, and great conversation. Always appreciate Nick and Calvin, kind of your insights on the constant daily sand shifting and battle that we do for our clients in the cannabis space. So do appreciate it, and looking forward to getting this two of you on another webinar. Hopefully, there's some updated information to move us in the right direction.
Yeah. Hey, Cory.
Yeah.
We are considering doing another webinar after we see something this week from the Ultra Health case. So that is something we're looking at. And I wanted to just say one thing, a little off script here, but hemp, right? I think it's important that people know because a lot of cannabis companies have hemp lines as well and things like that, right?
Yep.
And hey, look, guys, the law is going to change on hemp, right? And those intoxicating beverages are going to become illegal in about 7 months now, 8 months, something like that. And once they are going to go to Schedule 1, assuming that that's still moving in that direction. And once that happened, two really important things to understand. Number one, no bankruptcy, right? So if you've got a hemp line and you need to declare bankruptcy, you got to do it now, because if the law changes and you're in bankruptcy, you're not going to get a discharge, you're going to get a dismissal. And that's not going to be good. And the other thing that can happen at that point is 280E can apply. So now deductions and maybe even losses are no longer deductible, right? So if you are a company that has a hemp line, you need to start looking at that.
Yeah, that's a great add-on. It's cautionary for like I said, particularly folks that are selling the beverages not through a license, I guess is how I say it. But
yeah.
Yeah, again, that's an interesting world that's really changed in the last 6-9 months.
And it could go back the other way, right? But if nothing happens, it's going to change, right? So that's where we're at.
Yep. Oh. Anyway, you guys, great conversation. Again, appreciate both your times, and looking forward to hopefully a great conversation on the updated court case.
Yeah, I was going to say both Nick and Cory, thank you very much. I appreciate being able to participate in this soon. Everyone have a great day.
Oh,
thank
Nick,
you.
Where's the kittens?
Should I go get them? They're upstairs.
Yeah, real quick.
We got kittens here, guys.
Just a minute. We got to do it. He said he scored a couple kittens, so I thought he had them with him.
No, I guess you'll have to retrieve them.
Yeah, I forgot about the hemp THC clients. It sounds. I think he's having a tough time wrestling them up, herding the cats.
I did manage to corral one of them.
Yep, herding cats.
And we have two. There's about eight. They're about 8 months. And this one's name is Willie Nelson. Say hi, Willie.
Well, that was worth the wait. He's Willie's a pretty
Is the other one Mike Tyson?
No, the other one's Freddie Mercury. Yep. And supposedly they're twins, but they're not because Willie's a lot bigger than Freddie.
There you go. All right.
Well,
Thanks for sharing.
thanks for grabbing us, Nick. We'll talk to you
All right.
guys.
Thank
Bye.
you, everyone.